A will does not avoid probate in Georgia. A common misconception that I hear quite a bit when I'm meeting with clients for the first time and they have a will, or maybe they've read something online. To be clear, if you have a will in the state of Georgia, then, and you only have a will, by the way, then there's a very good chance that your family is going to have to take that will to the probate court in the county in which you resided in when you passed away and file it and ask for the court to legitimate or validate the will. And then they will have to administer your estate through the court process called probate. So how do you avoid probate in Georgia? There are only three ways to avoid probate in the state of Georgia. The first is don't own anything at the time of your death. If you don't own anything, then technically speaking, your estate has nothing in it and it does not need to get administered when you pass away. The second way to avoid probate in the state of Georgia is if you have an asset where you can name a beneficiary designation, such as a bank account, a brokerage account, a retirement account, a life insurance policy, then make sure that those beneficiary designations are up to date and in alignment with what you want to have happen to your estate when you pass away. The third way to avoid probate in the state of Georgia is if you own an asset in your name when you pass away, or if you currently own an asset right now in your name and you cannot put a beneficiary designation on it, and a really good example here is real estate, a home, land, commercial real estate, whatever it might be. But if you own it in your name, then you need a living trust. And a living trust is a particular kind of trust that you build while you are alive, and you will put that asset, that piece of real estate, into the trust. And then when you die, you do not have to go through probate, or you won't go through probate. Your estate will not have to go through probate, and your family will not have to use that will and will not have to file it with the court and ask the court to have that asset get administered by the court. In that process, again, that's called probate. When you have to go through the court process of administering estate, that is called probate. So, a will alone does not avoid probate. A beneficiary designation and or complemented by a living trust, that is the only way to avoid probate in the state of Georgia. Well, outside of not owning anything, but I don't recommend that. So if you have a will and you want to avoid probate, then reach out to us here at Atlanta Wills and Trust Law Group, where we help women protect who you love the most, and we can help out.